Hello, everyone. Today, our topic is how to protect your home and savings. And I'm going to share my screen with you so that you can follow along with me. My name is Thomas Vick. I'm the attorney at Vick Law. And we provide legal services in estate planning, estate administration, and elder law. And from time to time, we provide webinars and other information to the community about estate planning and elder law and estate administration. And today the topic is how to protect your home and savings. It's an important topic, and sort of the quote that we have for today is plan today and be prepared for tomorrow. We're going to talk about some of the risks that tomorrow might bring and how we can plan for those in the present. First of all, some statistics and possibilities to throw out there. First of all, most studies show that 1 out of 4 people will need some type of long-term care in their lives. And in fact, this probability increases with age. There's a study out there that says 52% of people who turn 65 today will develop a severe disability requiring long-term care. So about half of the people that turn 65 today will have some need for long-term care. And the Department of Health and Human Services estimates that 70% of all people over age 75 will need some type of long-term care in the future. So there's a significant risk that any person that comes into my office and speaks to me, there's a significant possibility that that person is going to need long-term care. And there's the fact that long-term care is very expensive. I've provided similar statistics in other presentations about this. Medical care and the cost of long-term care will be the greatest threat to a client's home and their financial resources. On average, nationally, the hourly rate for a home health aide is about $20 an hour. For an assisted living facility, it is about $43,000 a year. And a long-term care facility for a shared room is approximately $82,000 a year. And if you want a private room, then the cost of that is $92,000. So any way you slice it, it's going to be expensive. In 2013, Americans spent $339 billion on long-term care, and 72% of this was paid for by Medicaid and Medicare. And private insurance and out-of-pocket expenses totaled about $97 billion. So the great majority of people are paying for long-term care through these government programs, Medicaid and Medicare. So that's a reason why we would want to plan. Those are the risks that tomorrow holds. But then there's also this significant factor of what about the family? Family is the biggest long-term care provider. In 2013, the economic value of family care equaled about $470 billion. And then family care is worth more than the value of professional care at $339 billion. Family caregivers, especially spousal caregivers, are at a far greater risk of serious health problems or even death. There's an emotional burden and also a physical burden on family caregivers, and that bears itself out on in these statistics that family caregivers are at a far greater risk of serious health problems or even death. So how will you pay for long-term care if and when you get sick? There are a lot of different options. First of all, your monthly income, your Social Security benefit, your pension each month, your IRA, your 401k may be used. to pay for your long-term care. You may have to dip into your savings to pay for the long-term care. If you're fortunate enough to have a long-term care insurance policy, that could be used to pay for your care. But then that long-term care insurance policy, it may or may not cover everything that you need. Maybe you simply rely on family, public benefits. Maybe you have to sell your home so that you can pay for your care in a nursing home. Or you can implement a legal plan to protect your home and your savings. Implement a legal plan to protect your home and your savings, or a combination of all of the above. And that's exactly what may need to happen in your situation, that you take from all of these possibilities and you plan for receiving public benefits. You understand that you may need to use some of your savings and your monthly income, but you have a plan in place so that a portion, or maybe even all of your savings, or a big chunk of it, is safe from having to be spent on your long-term care. What do we want to avoid? We really want to, and these are the goals that we have. We want to avoid running out of money for yourself, your spouse, and your family. We don't want a long-term care situation to turn into a crisis that renders the parents and the family to a point where they don't have any money. We also don't want to leave the home unprotected. We want to make sure that the home is in a place where it stays in the family. We want to make sure that the parents are able to stay at home as long as possible, but we also don't want that home to have to be sold to pay for that parent's care. We want to keep that home in a place where the family can have it for future generations. And then also, we don't want to risk the health of family or spousal caregivers. So we want to develop a plan that will protect their health as well. Why do we want to do pre-planning? Here are some of the reasons. One of the most common reasons that people do estate planning is to avoid probate. Probate isn't horrible, but if you can avoid it, you should. So avoiding probate is one reason, but then also to avoid family turmoil and conflict. The fact is, when there's not a plan in place, or when there is a plan in place but it hasn't been thought out very well, then there can end up being a lot of family turmoil and conflict as a result of it. And so that's one reason why you would want to do pre-planning. Avoid all of that, get a plan together so that everything is taken care of and you can address conflicts before they arise. Another reason is to avoid guardianship procedures. Maybe not only is there, you have a power of attorney for a reason, and the main reason is to avoid having to go to court and set up a guardianship. If you don't have a power of attorney and you become incapacitated, your loved ones will have to contact an attorney, get in touch and file a petition to establish guardianship. It might be a guardianship of the person just to take care of the health of, for instance, a parent, but then also it might be a guardianship of the estate to take care of the financial resources of the parent. We want to avoid all of that by doing some pre-planning. HIPAA concerns are another reason. We want to make sure that people have the documents in place to talk to doctors regarding their parents or whoever their loved one may be. Tax benefits. We want to make sure that we have the optimal tax treatment with our stuff, with the house and the real property, and the IRAs and 401ks, all of that. We want to make sure that we have the best tax benefit that we possibly can have. So to utilize all available benefits is the reason why we want to do pre-planning. Understanding that there are medical risks in long-term care, and also that we want to address family dynamics. No family is the same, and you know, relying on an attorney's experience to cipher out what needs to be done with certain property and how to handle distribution to family members, that can all be done through pre-planning. Especially if there are, for instance, mixed families with second marriages. How do you handle children from a spouse's previous marriage? Trying to treat everybody equally. That's a good reason why you would want to do pre-planning. To address the special needs of family members. Perhaps there is a special needs adult child or minor child. How do we make sure that that special needs individual has exactly what they need in the future? Do you need to establish a special needs trust for that family member? Those are some of the reasons to do pre-planning. Here are some typical estate planning documents. First of all, a revocable trust to avoid probate, and then sort of keep, you know, to govern what happens with your property after you pass away. The way that you can do that is through a revocable trust or a family trust. Perhaps the family comes together to make sure that an individual has you know, a special needs individual has everything that they need as far as government benefits are concerned, and then extra. A pour over will. This is a will that basically covers the, you know, covers the basis when there's a revocable trust. So we try to put as much as we can into the revocable trust. And if for some reason we didn't get the trust completely funded, we have a will that pours over into the revocable trust at death. The standalone will, perhaps a standalone will is all that you need. This might be the case for young couples that have, young married couples that have a minor child and they want to name somebody as a guardian over their minor child if for some reason the parents are sick, or if they predecease. A standalone will is a way to do that. Some other typical estate planning documents include a durable power of attorney, which is a document that allows you to make financial decisions in the main for an individual. The healthcare power of attorney to make healthcare decisions for somebody. The advanced healthcare directive, sometimes called a living will, is another reason, so that you can state your preference as to end-of-life decisions. And a HIPAA release, so that the healthcare power of attorney can talk to the medical providers about your care. All of those are typical estate planning documents. Sometimes people do it themselves, DIY estate plans. Sometimes they decide that they will deed the property to a child to avoid probate, put the child on bank accounts. They might do a do-it-yourself simple will, give money away, give valuable assets away, and they don't consult an attorney regarding those transfers. And there are a lot of reasons why those are not optimal and can actually be devastating to a family if individuals decide to go that route. These are some of the problems with that kind of planning. First of all, a simple will probably won't achieve what you want it to achieve, and it probably doesn't factor in all of the possibilities that could happen. That's, you know, that's why you would want to go with an estate planning attorney that has experience, has the right documents, so that you can achieve what you truly want to achieve. Um, and the second bullet point there is that those transfers run into problems with the look-back period when qualifying for public benefits to pay for long-term care. Any one of those transfers, deeding the property to a child, that will draw a penalty. Putting a child on the bank account has issues with creditors. If the child were to get into financial trouble, that's an asset that they possibly could have a creditor levy on. Giving money away, giving valuable assets away, those draw penalties when it comes to Medicaid. The third bullet point there, expose your assets to potential liability claims from creditors or judgments. What happens after you deed the farm away and then you have a creditor of a child who received the farm come and sue that child and begin to make collection action against the farm? Well, you've compromised the farm, and you don't have any control over what happens with it at that point in time. And then also you limit future distribution options. Once those pieces of property are gone, they're gone. And it's really subject to what happens to the children and what the children want to do with that property. So you limit your future distribution options. So there are a lot of different problems that come with that do-it-yourself planning. Penalty periods, they don't contemplate the look-back periods, creditor exposure, limitations of future distribution options. Simple wills don't achieve what you want them to achieve. And then often there won't be the optimal tax treatment that you would like to have. Here's an example of bad planning. Some parents deeded their home to their child. This was done because they wanted to make sure he had the home without having to go through probate. The child subsequently sold the home. The parents had no savings and a very small monthly income. 2 years after deeding the home to their son, the dad became ill and had to go into a nursing facility. Unfortunately for the parents, they had no way to pay for the long-term care and were unable to get Medicaid because of a disqualifying transfer. So they've got no money, and they don't have a possibility of selling the home to pay for the long-term care. Medicaid's not going to cover it. They're stuck, all because they did it themselves. So, and unfortunately, that kind of do-it-yourself planning is fairly common. What are common goals in doing long-term care planning? To age with dignity. I don't know of a single client that says, I want to go into the nursing home. They instead are saying, I want to stay at home as long as I possibly can. I don't want to go into the nursing home. Well, by doing pre-planning, we can put that plan into place. And to the best of our ability from a financial standpoint and from a community health standpoint, we can do that. Another goal is to just have options if long-term care is required. You might have a long-term care insurance policy, and that may cover you for a period of time, but it may not cover everything that you need. So let's do pre-planning so that we have all the options possible. Another goal is to identify who will take care of you and who will help you manage your resources and assets. Identify these people who will take care of you now while you can. Otherwise, you may have somebody taking care of you that you don't want taking care of you. Your family should know who's going to be in charge of taking care of the parents. And then also to leave a legacy for your loved ones. Often it's the case where people have retired and they've they've lived a while after retirement and they still have a chunk of money that they want to preserve and make sure that Medicaid doesn't take it, so to speak. Um, one of the goals that can be achieved through long-term care planning is making sure that that legacy is preserved for loved ones. So age with dignity, having a say over how you are treated, have the best options available if long-term care is required by maximizing your funds and available benefits. It'll give you the power to choose who will manage your financial and medical decisions if you're unable to do so in the future, and to leave a legacy for your loved ones rather than burdens. Those are goals that are met by pre-planning. So what can you do? Well, there are so many things that you can do, and the best way to find out is to just contact an elder law attorney to provide you with information you need to achieve the goals you deserve. So the main thing is contact an elder law attorney to discuss your options. What is an elder law attorney? An elder law attorney deals with a lot of different areas of law. Asset protection, veterans planning, dealing with veterans aid and attendance, so that there's some financial income coming into a veteran or a surviving spouse to assist with activities of daily living. Healthcare planning, how does Medicare relate to Medicaid? What's covered and what's not? An elder law attorney knows those fine points of detail. An elder law attorney deals with estate planning, advance directives, wills, trusts, elder abuse and fraud. An elder law attorney will find out about, whether, if mom or dad is not being treated right in the nursing home. An elder law attorney deals with that kind of thing. Guardianship, perhaps the parents didn't get in front of these areas prior to their incapacity, and a guardianship needs to be set up. That is one thing that an elder law attorney does. Special needs planning, preserving government benefits for an individual with special needs. That's part of an elder law attorney's job. Long-term care planning, advising clients on long-term care insurance, and if they can't afford that, what are some other options available? Social Security and Social Security disability, that also is part of an elder law attorney's wheelhouse. And then Medicaid planning. Let's say a parent is going through, going into a nursing home or needs Medicaid waiver to come into the home and provide some services. How do I preserve as much of the financial resources as possible? Those are some of the areas that an elder law attorney deals with. And really what you need to do is contact the elder law attorney, contact our office. Our phone number is 317-884-3133. Get in touch with us, ask us whatever questions that you have. We provide free initial consultations, and we hope that you can contact us, and we can provide some solutions to the problems that you're dealing with.